As always, the best place to start is at the beginning. Petitioner Coalition Life is a Missouri nonprofit that organizes sidewalk counselors to counsel, educate, pray, display signs, and distribute literature outside abortion clinics. Their goal is to engage in one-on-one conversation in a calm, intimate manner, as they find that approach most effective. The organization prohibits its counselors from engaging in intimidating or threatening behavior. Sounds like a simple example of exercising the right to peaceably assemble to me. But if it were that simple, I wouldn't be recording this episode. Until the passage of ordinance number 2023-03, Coalition Life counselors engaged in sidewalk counseling outside abortion facilities in Carbondale. But the new ordinance severely hindered their ability to do so. The newly enacted 100-foot buffer zone meant that Coalition Life counselors were forced to stand far away from those with whom they wished to speak. In some cases, sidewalk counselors had nowhere to stand but in the middle of busy roads, rendering intimate counseling activities effectively impossible. Imagine being told that you cannot come within 100 feet of a location simply because you disagree with its stated purpose and wish to discuss the facts with their customers. Again, we aren't talking about intimidating behavior. That was prohibited by Coalition Life. And if someone prevented someone from entering said business, I believe that would be criminal as well. But according to the complaint, none of that ever happened with members of Coalition Life. Coalition Life sued the city of Carbondale, alleging, among other things, that the ordinance violates the First Amendment. Problem number one for Coalition Life is the ordinance cannot violate the First Amendment because it wasn't passed by Congress. Remember, the First Amendment reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech. Since Congress didn't make this law, it cannot violate the First Amendment. But that doesn't mean the act was unconstitutional. All persons may speak, write, and publish freely, being responsible for the abuse of that liberty. Now, since this is a violation of the state constitution, it's not within the jurisdiction of the federal judiciary. However, that isn't the only violation of the United States Constitution. The 14th Amendment reads, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. Since Carbondale made and enforced an ordinance that abridged the right of freedom of speech and deprived people of their liberty to engage in conversation with others without due process of law, it is a clear violation of the 14th Amendment. The complaint may have mentioned other violations, but it appears only the First Amendment question was brought to the court. Needless to say, the city of Carbondale wanted this suit to go away. When Carbondale moved to dismiss the suit under Hill, Coalition Life responded that over the years, Hill has been eroded, but it nevertheless conceded that its claims were foreclosed insofar as Hill remains good law. When the city moved to dismiss the suit, they pointed to a Supreme Court decision known as Hill versus Colorado. This leads to the second problem with the Coalition Life case, the belief that the previous decision of a court is law. It is not. Hill is precedent, showing how the court had previously decided a similar case. The importance of this will become evident as we get into the dissent. The district court dismissed the suit on the grounds that Hill and binding Seventh Court precedent controlled. The Seventh Circuit affirmed on the same grounds, acknowledging the plaintiff's assertion that Carbondale's buffer zone was modeled after and nearly identical to the one upheld in Hill. Because Hill was the exclusive basis for both decisions below, this case clearly and cleanly presents the question of Hill's viability. So this whole case was decided because it matched the case Hill versus Colorado. But was that case rightly decided?